Morning, Greg Willard.
Good morning, McGraw and Kelly.
Good morning.
St. Louis University law professor, KTRS Legal Analyst. We're going to have to double your salary for coming in here as much as you are. All right, so what did our Attorney General say yesterday? What is this new allegation that our sitting governor did?
The Attorney General's office, McGraw and Kelly, had begun several weeks ago an investigation of the Mission Continues, the not-for-profit organization that Governor Greitens had been involved with. And it was a civil, a non-criminal investigation.
Right.
The Attorney General Hawley announced yesterday that his office had uncovered and had turned over to the prosecuting attorney, the circuit attorney in St. Louis, information which he believed constituted probable cause that a felony had been committed by the governor with respect to digital tampering. So the Attorney General does not have jurisdiction to prosecute that crime. So his office got approval from a court to turn over that information, that evidence, to the circuit attorney, and she will make a judgment, or a grand jury will make a judgment if she chooses to present it to the grand jury, as to whether the governor is going to be formally charged or indicted with that felony.
Okay, the statute of limitations apparently runs out Sunday?
I've seen reports that it runs out April 22nd, whatever April 22nd is. Yeah. But and presumably the criminal conduct, and we can perhaps connect some tea leaves, dots, McGraw and Kelly. It sounds like that the act of this digital tampering must have happened on or about April 22nd or 3rd, blank years ago, the blank being whatever the statute of limitations is.
Right.
Such that, and what a statute of limitations is for our listeners, is that after a period of time, a charge cannot be brought. It becomes stale.
Right.
And so the reports I've seen, McGraw and Kelly, April 22nd, that I think we can all say it's about to expire.
Okay, so in English, is Josh Hawley saying that he has evidence that our governor stole the email list from the Mission Continues?
Yes, and he's saying he has evidence that there was, in the words of the statute, there was digital tampering. But what it sounds like in plain English is that the governor accessed the computer system of the Mission Continues without authorization, which is an element of the statute, and downloaded or retrieved certain data, presumably an email list, and Attorney General Hawley believes that that is evidence sufficient to constitute probable cause that a Class E felony was committed by the governor. And he's referred it.
All right. And what is Class E?
Good question.
Class E, it's largely a function, Kelly, of the punishment. So right now he's about to be tried on a Class D felony invasion of privacy, and that has a 1-year incarceration and a $10,000 fine. So my guess is Class E has a slightly shorter incarceration period and probably a lower fine.
So Class A is the worst, and it gets better from there going down.
Yeah, the
Class D is worse than Class E.
Yes, that's correct, McGraw.
Okay. So can you commit a crime if you don't know it's a crime? In other words, can our governor say, all right, I took the email list. I didn't know I couldn't take the email list. I just thought I had it. I saved it. I just use it. I didn't know it was a crime.
Yes, you can be convicted of a crime not knowing that you committed a crime. To give you an example, if you and Kelly and I leave the studio today and we're driving north on 170, driving 80 miles an hour, and we're not aware that we're driving 80 miles an hour, Don't call me to defend you at that traffic court.
Right. No, I understand that. But everyone knows that going 80 miles an hour is against the law. But does everybody know that, email lists from this charity that I started, I am not allowed to use for my next business down the line?
Well, I guess we could bifurcate it, McGraw, law and ethics.
Right.
So let's say that somehow I have a password to the KTRS computer server.
Right.
And I log in and I start snooping around, reading people's emails, and I download your pay stub.
Right.
Well, I think anybody with brain cells between their ears would say that that's not ethically correct.
Right.
I think most people would say, I'm not certain, but that may also be a crime.
Right.
And my point is, McGraw, whether you're certain it is or it isn't, doesn't matter, unless the statute, remember, some statutes require an intent. You have to have a mens rea, we lawyers call
Right.
it. But I think in this case, if the defense is, oh, well, golly, I didn't know that the conduct that the Attorney General is alleging against me, I didn't know that was a crime, I think it's going to be a long day.
Also, remember, there is a former member of the St. Louis Cardinals front office that is sitting in jail after tampering with the Houston Astros computer programs. So this is not this is out there and it is happening, and people go to jail for this.
What if it was the governor himself, or did he put someone else up to it?
Another great question.
Well, if the governor put you up to it, Kelly, you're probably both criminally culpable. That you committed the act, but he was an accessory to the act. And so I think both of you are in criminal jeopardy.
There are a couple of former employees that are awful quiet about this. This one, Crystal Taylor, who apparently, through news reports, sent the email list at some point to this campaign manager who had it or something along those lines. Read the tea leaves for me. Why are we not hearing from any of these people? Why is... does Josh Hawley have access to these emails? Where do you think this evidence comes from? Rita.
Well, my guess is that the Attorney General's office had some computer forensics done on the Mission Continues computer servers.
Right.
And according to the governor or the Attorney General's statement yesterday, in the course of that investigation and what other evidence they may have compiled, that they came upon evidence that gave them probable cause that a crime has been committed.
Yeah.
So it's probably a combination of interviews,
Right.
witness statements, computer forensics, and other investigative techniques that they use, that the Attorney General used to reach this point.
The Mission Continues has said unequivocally, we did not give him access to anything. So they have distanced themselves from their founder in this.
Sure, because I think an element of the alleged crime under the statute, it has to be unauthorized. So if you and Kelly and I get together and I am given access by KTRS management
Right.
to access your pay stub, well, I can't be charged with tampering.
Right.
And so reading the tea leaves, to pick up on your question, McGraw, reading the tea leaves, I think what the Attorney General believes is that not only did the governor allegedly hack in or access the Mission Continues computer,
Right.
he was not authorized. And maybe he says he was. I guess that's why we have juries.
We also have laws out there and that say, and this is the criminality part of it, because there are charities and charity laws that say you're not allowed to use your database, anything you do in this charity, for political purposes.
Absolutely, McGraw. It's most charities are what are referred to as 501c3s. That's a section of the Internal Revenue Code.
Right.
And I've done a lot of work over the years with 501c3 clients, and it is not a red light. It is a gong and klaxon for a 501c3 to even get close to a political campaign or a political party. Clark Kent, that is kryptonite, my friend,
Right.
and stay the heck away of politicians and political campaigns if you are a 501c3.
Okay, so now Kim Gardner has this information from the Attorney General. Can she add charges to this trial, or is it going to be a new trial? How does she work this?
Well, we are at the stage 3 of about a 30-stage process, if it goes that far. But what she has, according to the Attorney General now, is she has evidence sufficient to constitute probable cause of the felony. She can do several things, three in particular. She can take a pass. Say, I don't agree, Mr. Attorney General. She can present it to a grand jury, as she did with the felony invasion of privacy charge. And the grand jury then can decide whether to indict the governor on tampering. Or she can file charges, and information it is called. And she can file charges down in the city circuit court against the governor, and it will proceed along the same lines towards trial unless after filing an information she presents it and there's what's called a superseding indictment. So
will he be arrested again if she, because now it's Sunday is the statute of limitations, so you don't have time for a grand jury, right? Or it'd be very difficult.
It could be it doesn't sound like a complicated case, so I'm sure there is a grand jury impaneled downtown that she and her office, if they are so inclined, could present the evidence to a grand jury.
Okay, if a grand jury comes back or she decides to charge him with something because the statute runs out by Sunday, will he be rearrested again?
Yes. Yeah,
they'll take another picture and
the whole
thing all over.
Yeah, he'll be booked again, and it's a constitutional, a criminal procedure that yes.
And so this hairstylist trial will be going on. That will be determined one way or the other, while this other trial is working its course through the.
It's working its way, and then as we have said on the air, the more legally significant, in my personal judgment, is this impeachment process, McGraw and Kelly. Those three will continue apace.
I guess my question is, they wouldn't, and again, only my legal expertise comes from you and law and order. So I'm
the latter clearly more authoritative.
You are no McCoy, that is for sure. But they would never co-join. Kim Gardner wouldn't co-join these two charges into one trial.
No, and I think I don't think the prosecutor would. I think constitutionally, just sitting here on a Wednesday morning, I think constitutionally that would be very unfair, whoever the defendant is, to conflate those two charges at a single trial.
I have one question, too. If this does go to, they file charges and they book him and have to go to trial, would Josh Hawley have to, would they call him as a witness? Or
Probably not, Kelly. Theoretically, it's possible, but my guess is that what Hawley and his investigators found and saw, that will be presented, if it gets this far, that would be brought into evidence by means other than Hawley and his investigators. So I think it is highly unlikely that Hawley or any of his investigators would testify. Maybe there would be an investigator would have to testify to authenticate some chain of custody, but probably we won't see Hawley testifying.
If Eric Greitens is charged with this crime, if he is convicted, a Class E felony, what are the chances of him going to jail?
Well, not likely on a Class E felony. It's not likely. If the defendant has been convicted of both a Class D and a Class E felony, so you have a prior felony conviction when you were up for sentencing on your Class E conviction, well, that raises the prospect that the sentencing judge may take that into account and say, I'm going to give you some time being incarcerated. But just as a general proposition, McGraw, a first offense, Class E, I don't think anyone realistically would expect jail time.
All right, now while this is going on, we can't avoid what's going on in Jefferson City because, and you have had a front row seat for the most famous impeachment of all, or one of the most famous was Richard Nixon. Watching what's going on down in Jefferson City, his own party is calling and publicly calling for him to resign. He apparently is not listening to them.
Yesterday, from a historical perspective, McGraw, was a fulcrum day. I'll tell you what I mean by that. In 1974, Richard Nixon had adamantly said, I will not resign. And the charges continued to build up, and he lost 8-0 in the United States Supreme Court. I will not resign. And the elders of the Republican Party, Barry Goldwater, Hugh Scott, came to the White House and said, Mr. President, it's over. And that led him to resign. Well, I think yesterday we witnessed that moment in this situation, in that Speaker Richardson, President Pro Tem of the Senate, the leader of the Senate, all three called upon the governor to resign. And in contrast to Richard Nixon, the governor said no. So I think where that leaves us is very clearly the legislature is going to call itself back into session, and I think very clearly we are going to proceed down the impeachment path.
Right. So you think yesterday was the proverbial governor, it's time, and the governor said no, it's not.
Oh, yes, I do. I think the historical analogy is stark. And the response of the two elected officials, Messrs. Greitens and Messrs. Richard Nixon, are equally stark. Now, again, the governor can have a change of heart and decide to resign, as President Nixon did. But by golly, McGraw and Kelly, he sure didn't give that indication yesterday. One thing I'd like to say, McGraw, before we go off the air, completely unrelated. But we lost a national treasure last night
with Barbara
Bush. She was just a wonderful lady of grace and compassion. I think in this moment of just cacophony from so many places and sordid behavior and sordid allegations, I think it behooves all of us to take a step back this morning and Saturday morning when we say goodbye to her at her funeral. That'll be televised. I think it behooves all of us to take a step back and say, that's what America ought to be all about. People like Barbara Bush and what she brought to the country and to our national core, if you will.
We are in a very different place, are we not?
A very different place, McGraw, and she will be sorely missed. She was a wonderful lady.
Greg Willard, keep your phone on and look to the skies for the Willard bat signal.